Hey patent friends, welcome back to another video. I'm coming to you today from Puerto Vallarta, Mexico, on vacation and working remotely a bit. So I want to talk today about billable hour versus flat rates and what you absolutely need to know before you work with a patent attorney and how to hire them. So stick around, we are starting right now. So for those of you who are new here, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's show, The Profit with Marcus Lemonis. So this channel is all about giving you insider tips on patents, hiring patent attorneys. So click subscribe if you want more content like this and hit that little bell icon so you don't miss any great videos. All right, let's get right into it. Okay, so the first thing to get out of the way is, you're probably gonna be thinking, well, hey Dylan, you're a patent attorney, you're just gonna be telling me something that only benefits you. Now let me just give you this pledge. If you contact me about this video or saying you wanna work with me related to this video, I will refuse to work with you just out of principle, because I want this to be unbiased information. You notice, like, I'm not gonna give you my phone number, I'm not gonna give you my email. I just wanna kind of give you the insider information about how billable hours work, about how flat rates work, and how it may be surprising the way these things actually work on the, sort of behind the scenes when it comes down to it. So if you're hiring a patent attorney, it's good to understand what you typically are hiring a patent attorney for. So the basics is going to be planning patent protection, determining, whether what you have is generally patentable, when to file patent applications, how many patent applications file, what sort of applications. Then it would be drafting and filing those patent applications at the United States Patent and Trademark Office, and then working those applications through the examination process. Patent attorneys will sometimes kind of help with things like enforcement or defense if you get accused of patent infringement. And I have a bunch of videos on this, but a lot of times, patent attorneys, will do things like prior art searching or freedom to operate or infringement analysis. But a lot of times, those are kind of ways that attorneys upsell people. I'm not a big fan of doing prior art searches aside from really simple inventions, but that's kind of for another video in a lot of ways. I mean, for this one, it's good to understand that those things tend to be sort of on a project basis. And that being, so for instance, you'll have a patent attorney draft and file a provisional patent application, and then that provisional application lasts for 1 year, and then you have to file the non-provisional. And so in a lot of ways, it can be the kind of work that works well, potentially, with flat rate stuff, where there's just a single set price for whatever that work is, for whatever that project is. Or a lot of attorneys are going to work on a billable hour rate. Now, which one is better? And I think it's really counterintuitive. And be sure to watch the end, because I'm going to give you really the important tips you need to know before engaging an attorney and before you do any more work with your patent attorney. So for me, I've been doing patents for a long time. I started my practice back in 2005. I was actually in law school. I passed the patent bar and started my own solo practice while I was in law school as a patent agent. That's when you pass the patent bar, but you aren't an attorney yet. Started a small firm with a friend of mine when I was in law school. And then when I graduated law school, passed the bar, I became a patent attorney, and then transferred my practice to a boutique firm, a small patent firm, and then later on moved that to one of the largest firms in the world. And now I'm at a firm that's kind of a mid-sized, large firm, about a little over 600 attorneys. So I've seen a lot of different pricing models. I've seen it, from being an individual to, to massive firms. And I've noticed a lot of things that are similar when it comes to flat rate stuff and when it comes to doing things by the billable hour. So I gotta be honest, I'm not a big fan of doing stuff flat rate. And what I found is that those firms that are doing flat rate stuff, it gives people a false sense of security when it comes to better pricing. It kind of lulls people into thinking, oh, it's, this is more predictable, it's, it's flat rate, this is better. But in the end, doing stuff by the hour tends to give you better quality work, it gives you better value, but it's more about trust. And let me kind of explain why that is. So one of the issues with doing flat rate work, that's where you do say a specific project for a specific amount, like say like drafting and filing a provisional patent application, or doing a prior art search, or drafting and filing a non-provisional application, or drafting a response to an office action. The issue with that, especially say early on in the process, so if you're going to be doing like say a provisional patent application, it really incentivizes the attorneys to not do as good of a job, to spend less time on it, because if anything, they want to spend a little bit of time and get a lot more money. That's the way it ends up working out. So it incentivizes doing less work up front, which in the end costs you a lot more in the long run. Also, say during processes like the examination process, it incentivizes the attorney to do just the basic amount to get a response in, but not something that's actually going to progress the examination process. And I see this all the time. And so for instance, like, you file your non-provisional patent application, it waits in line for 1 to 3 years, and then you get an office action which has the rejections. You draft and file a response, and then the examiner does a new prior art search and then comes back with new rejections. Now, theoretically, this could go on indefinitely. You could get an office action, file a response, get an office action, file a response, get an office action, file a response. And a lot of the firms that do this flat rate work, they're just doing the bare minimum just to then get another office action and charge you more, get another office action and then charge you more for a response, instead of by the hour, which tends to be like, okay, let's do what needs to be done to get this case to allowance. At the same time, you want to leave time for appropriate negotiation. The examination process should be thought of as a negotiation, like say in Pawn Stars or American Pickers, where there's supposed to be this back and forth. Like, that's how you get to the best deal when it comes to being a buyer, just like it comes to getting the best deal when you are, you're the one trying to get a patent. Sure, you could easily, go like a negotiation. Like, let's say there's a house, on sale, and they're offering $100,000. You're like, I'll take it for $200,000. Well, sure, obviously, then you would get that house. It's kind of like in patents too. Patents are they're a spectrum of protection. You can have really broad patents or really narrow patents, and you can easily just go and get the most narrow patent ever, and yeah, you're going to get that through. But what can also happen is that the patent attorneys who are going to try to string things out and charge you a ton of money, they start out with absurdly broad claims and then slowly narrow over time, or just argue. And while it's going to be over say 5, 6, 7 years, it's going to be maybe a few $1,000s every 6 months, every few months. In the end, it's going to cost you way more than it would had you just spent a little extra time to do things more quality up front. And that's one of the biggest problems I see with doing stuff when it's flat rate work. Along with that, it also incentivizes the attorneys not to spend a lot of time with you. One of the things that's really important, especially for startups and people who are new to the patent process, is to understand what's going on. How are you going to be able to take advantage of your patent assets and use them, to their fullest extent, and get the most value out of them if you don't have somebody to consult with? And the attorneys who are on the flat rate for, say, doing one service or the other, they have no incentive to spend this time with you to teach you about the process, about how to get the most value out of your patent assets. Along with that too is there's a lot of incentive to use absurdly cheap labor. I mean, I can't tell you how many times I've seen work from these flat rate firms that seem to have really super low rates that seem really affordable, but sometimes they won't even have real patent attorneys working on it. It'll be somebody who isn't really a patent attorney or isn't really a patent agent. They're the ones doing the work, and they're like totally not qualified to be doing it. They're just sort of supervised by a patent attorney, but then again, it's not quality work. It's not the kind of work that's actually going to get you to allowance, or at least not get you to allowance really quick. And so it may seem, in the short term like it's inexpensive, but in the long term, you typically are paying a lot more money, and then the end product is going to be usually pretty crappy. And what tends to be true about these firms that are working on these really super low rates, honestly, sadly, they're a lot of times banking on your failure. Let me explain what I mean by that. And so startups a lot of times are not successful. It is really difficult to start a new business or to to create a new product that you're going to be selling. And a lot of these companies know that. They're not really investing in you long term. They just want to get a few $1,000s out of you, knowing that, well, these people aren't going to be successful. Who cares? I'll just drag out this process for years and years and years, knowing how long the patent process is. And they're just kind of looking to make quick money on people. I think that's the thing you want to really look for when you're trying to find a patent attorney, is somebody who's going to kind of invest in you. I mean, not literally invest in you, but figuratively, somebody who wants to be your partner with you long term. I mean, again, not literally investing as, they're not going to like be an investor and invest money in you, but who wants to take the time with you, because it's a long-term relationship if you're doing it right. I mean, I have had clients who have, they've been around for like 15 years or so, 15, almost 20 years now. So it tends to be a long-term relationship, and done right, that's how people should be building it, instead of just, trying to make quick money off of somebody. Flat rates tend to be good for some folks, but usually that's going to be huge companies who have maybe hundreds, if not thousands of patent assets, and then it kind of makes sense to do it on a project basis. Say, for instance, several $1,000s for each office action, and a fairly flat rate when it comes to drafting provisional applications or drafting non-provisional applications. For companies with large volumes of stuff, then it makes sense. It makes things more efficient. But for startups, for individual inventors, it tends to be so much better, and you're going to get a lot more out of it if you do things on an hourly basis. Because there's a lot of times where people don't need, they don't need tons of time. We can do it in a lot less time than we would, than it would have cost, say, on some sort of flat rate or something. Other times it takes more time. It just takes that. And you should have an attorney who's going to tell you straight up, be like, hey, you need to take this time, it's gonna cost more. Or somebody who's gonna be more of a consultant and take that time as well. But it comes down to trust. You really need to find somebody that you trust and think of it like that. You're not just, hiring somebody to just do a job, like, hiring somebody to like build a deck or something. I mean, this is somebody who you should consider to be as like a long-term partner of your business. I mean, that's the way that you should really treat it. And that's, the whole difference between, flat rate and billable hour. People think that there's safety in flat rate stuff, but in the end, far more of the time, people are taking advantage of the, of the flat rate thing, and the attorneys are making, per hour that they're actually spending, they're making way more money than us, by the hour attorneys. So thanks for watching this video. If you got some enjoyment, or you got some, something useful out of this, be sure to give it a thumbs up. And if you want more content like this, be sure to subscribe to the channel, hit that little bell icon so you don't miss anything. And let me know about what you think about in the comments. Do you agree? Do you disagree? Have you hired an attorney flat rate or by the hour? I'd love to hear your experiences. Thanks for watching, and we'll see you again in the next video.